Yes.
Mr. Fenwick, I'd like to turn now to the issue of public interest immunity in the HIV litigation. Just so that those following understand in broad terms what this means, would you agree that this is an exception to the usual rules of disclosure, which means that a government department in this instance doesn't have to produce material to the other side in litigation because there is a overriding public interest in maintaining the confidentiality of that material?
Almost. My understanding was and is that where a document falls into that class, it's not the department doesn't have to, but the government must not. The only person who can decide that the document should be handed over despite that public interest is the judge.
The position, we'll look at that position in more detail as of 1990, but the point you make there about it being a duty and not a discretion, the government must not allow this material to be disclosed, is an important one. When you were asked to advise on public interest immunity during the HIV litigation in 1989 and 1990, how much experience did you have of PII matters?
Relatively little. I think from reviewing some of the documents you provided me with that there was some involvement in relation to Oprin. It is possible that I had looked at it in relation to one or two other bits of litigation I'd handled for the Treasury Solicitor, but relatively little, which is why, as I think I recorded in my advice, I had discussed it in detail with Andrew Collins and then later discussed it with the Treasurer Devil.
That's John Laws.
John Laws, yes.
Both of those, is it a fair assumption both of those had vast experience in PII matters?
Vast experience, yes.
You say in your statement at paragraph 18.2 that you recalled a telephone conversation with John Laws specifically on PII matters, and that you took some reassurance in the fact that he agreed with the approach that you had taken.
Yes, I mean, what I recollect is discussing with Andrew Collins in advance, doing my work, discussing it with the department, rechecking it, and then John Laws having access to what I had done, and then saying he'd like to have a conversation with me. You know, in the odd way that memory helps you, I remember exactly where I was sitting when I had that conversation. I mean, I knew John, but this was the first time that I'd spoken to him as, so to speak, his subordinate doing an exercise of real importance to get it right.
And his view was that you had got it right?
As far as I can recollect, yes.
You address at paragraph 18 in your statement, or section 18 of your statement, a conference that took place on the 18th of May 1990, of which we have a rough note. The inquiry has looked at that before. It's the note that refers to we must stop destruction on the date that litigation comes on. I'm not going to take you to that because you've dealt with the issues in your statement, and I merely draw people's attention to those. What I would like to take you to, though, is the written advice that you gave on PII, which is the 4th of July 1990. And if we could have on screen, please, DHSC 304360_072. Building on the discussion that we had earlier, am I right to conclude that your view is that this is a better evidence about the approach that was taken to PII than the rough note of that conference on the 18th of May?
Yes.
This advice, I won't take you to the page, but it's signed by you alone, dated the 4th of July 1990, and it's entitled Re-HIV Litigation Claim to Public Interest Immunity. If we just look at the first paragraph there, what you write is this: the classes of documents involved. The documents which I have been instructed to consider fall into 6 different categories, for each of which a possible claim to public interest immunity may be made out. I'm not going to take you through every word of this document, but if we just look at the different categories that you identify. The first is there, documents revealing the process by which policy decisions were arrived at, comprising submissions to ministers and exchanges with ministers, and subparagraph 2, exchanges between senior officials specifically forming part of a process by which submissions, draft submissions and policy documents were brought into being. If we go over to the next page, please. Oh, sorry, the bottom of that page still. The second category of documents to which PII may be attached were position papers and similar documents which were prepared by civil servants and directed towards the formulation of future policy and plans. Next page, please.
There is that important caveat at the
Sorry,
bottom.
if you go back then, please. We'll read the whole of that. Position papers and similar documents which were prepared by civil servants and directed towards the formulation of future policy and plans, but which were not designed to be placed before ministers or to form the direct basis for a submission to ministers.
Yes.
Then if we go over to the next category, briefings to ministers directly relating to parliamentary questions or debates, and particularly draft parliamentary answers and notes in respect of possible supplementary questions. The next category is briefing notes and draft replies to letters, consisting of briefing notes to ministers prior to other meetings at which they were expected to make a statement or declare their views, and draft answers to be sent by ministers in response to letters received by them. 5, the fifth category, the original unexpurgated versions of documents in or by which doctors and others supplied details of patients' illnesses and or adverse reactions in confidence to or for the CSM and or the licensing authority. And category 6, documents forming part of an exchange of information between the UK government and foreign governments or government agencies, containing information or views expressed by such foreign governments on the basis of express or implied confidentiality between governments. I'll just pause there for a moment. Those last 2 categories, 5 and 6, don't appear to have been argued over in the litigation that followed. Do you know if PIO was ever claimed over such document?
I'm sure it was. I mean, 5 is a well-known thing which I'm sure you're practicing here. What happened with the CSM and the licensing authority is adverse reactions were reported on what were called yellow cards, which would include personal detail of the patients as well as an adverse reaction. And so what we're dealing with here is the original unexpurgated versions. So there will have been disclosed a redacted version which hadn't got identifying marks, and that was, I think, not controversial. And then this question about documents, if there were any between governments, in order to pass on information, but with an expectation of confidentiality, and the views were being expressed by a foreign government. Again, I don't think that was challenged.
I certainly haven't seen any documents to suggest that it was. If we turn back to the documents, so in that first section, you've set out 6 different categories of documents. Then if we turn, please, to electronic page 3, you, in this section, set out the subject matter of the documents that you have classified into those 6 different categories. I'm not going to go through that, but we can give just an example of one. If we look at the subparagraph 1 there, this is category 1, so the documents revealing the process by which policy decisions were arrived at. And then you subdivide that category into A, documents relating to decisions which are clearly major matters of policy, and you give as an example whether or not to adopt a policy of self-sufficiency in blood products. You give some other examples as well. And then the second subcategory, B, is documents relating to decisions which contain some elements of policy, but which are subordinate to major policy decisions of the kind set out above. and you give as an example what approach to take towards the widespread introduction of vaccination against hepatitis in the light of the AIDS problem. Again, you give other examples as well. I'm just trying to give here a flavour of the approach that you took to that advice. If we could then turn, please, to page 5, electronic page 5 of the document. After having gone through each of the categories and set out the subject matter of the documents contained therein, you turn to the public interest which is at stake. And that is you identifying the basis, as I understand it, for which PII might be claimed on these documents. Is that right?
Yes.
And again, I will give just one example. If we look at yes, paragraph 3 there, and I quote, "In my view, and having discussed the position in some detail with Andrew Collins, QC, the public interest which is at stake in respect of each category and the mischief which a claim for PII would be designed to prevent can be summarised as follows. Categories 1.1 and 1.2, the documents referred to in paragraph 2.1a above fall within the class of policy-making documents in which 1. There is a need for effective, candid and uninhibited advice to ministers and discussions between ministers and their senior advisers. And 2, there is a public interest in protecting from possible critics the inner workings of government in the formulation of important government policy." You then go on to discuss some further aspects of that in relation to some of the documents that you've identified. So this is you setting out the reason, the basis for which PII would be claimed for that set. If we just go down on page, electronic page 6, please, to your comments about the public interest for category 2, the position papers. You say this, and I quote, "This category requires protection insofar as the working papers are designed as preparatory steps in the formulation of possible policies and strategies, which in due course will be developed into submissions and briefings to ministers. However, insofar as they represent merely papers concerned with how to implement existing policies, I do not consider that they should enjoy protection or that a claim for public interest immunity should be made for them." Now, firstly on that, do we see again that distinction between policy and operational matters that we have discussed earlier?
Yes. When I say I do not consider, it's not I don't think. It is I don't believe they fall into the category which is to be protected. So it's not a value judgment by me. It's a judgment as to whether or not they fall within the strict categories.
So this is not a document for which a claim for PII can or should be made?
Correct, yes.
And you say in your statement, paragraph 18.1, that when you were advising on PII, you tried to avoid taking a blanket approach. Is this an example of where you are avoiding such a blanket approach, not saying all of these documents necessarily fall in?
Yes, it's, there's an awful lot of documents here which we had to consider compared, I think, to some other cases and to classic PII cases which I dealt with, for example, as a judge when you're dealing with criminal matters. I took the view, and I think Andrew Collins and others agreed with me, that we needed to be quite granular in looking at them. We didn't want to sweep classes away and claim blanket immunity, but really to assess them, particularly so that if there was a challenge, which we expected there would be, then the court had the best possible information of the kind of documents rather than a wide sweep. Policy documents is not very helpful. Documents about the use of resources is not very helpful. So we tried to break it down, and I was trying to identify where, in my professional view, the line fell between the policy and the operational side, and therefore whether the claim should or should not be made.
When you say that the court would have had that information available to it so that it can consider and, if necessary, challenge those distinctions that you have made, that's not just the judge, is it? It's also the plaintiffs would have had that information provided to them.
Yes, when, again, I can't remember the exact sequence, but I know that in due course a certificate was prepared which set out the categories with some detail, and I don't remember how much detail. That will have been signed by the minister, and that was the subject of debate between the parties, with, I think, probably Rupert Jackson arguing it for the plaintiffs, and probably Andrew arguing it for the department. And first of all, Mr. Justice Ognall, then the Court of Appeal, particularly Lord Justice Ralph Gibson, looking at those categories. They were not looking at that stage at the individual documents, but at the description, and therefore it was important that the descriptions I gave were a fair description of the documents contained in that class for which we were asserting the privilege.
It was also important, wasn't it, to provide a degree of detail,
yes,
so that they could analyse whether or not that was a proper claim for PII.
Yes.
We look in due course at the Court of Appeal judgment, but we can see from that judgment that the categories that you set out here did form were used in the application that was made, and it was ultimately signed by the permanent secretary rather than the minister, because the
yes, because there were two administrations, exactly. So
yes,
Conservative and Labour. That was, I think, the convention.
If we could turn, please, to page 8. Having gone through this process of identifying the categories, the types of material within them, and the public interest that may form the basis for PII, you then go on to discuss the various strengths and weaknesses of the claims for PII. What you say in paragraph 4 is this, and I quote, "It is clear from the authorities that where documents are protected by public interest immunity, the department or person concerned has no discretion but is under a duty to claim the privilege." I pause there. The authorities there is a reference to the legal authorities, isn't it? Case law. And that is the point that you were making earlier, that if PII applies, it can't be waived by the department, it must claim it. It is then, and I go back to the document and I quote, "It is then a matter for the court to decide whether the balance of the competing public interests lies in favour or against, in favour of or against disclosure. There is nothing in the documents that I have seen which I would expect to have any significant adverse effects on the case to be put forward on behalf of the central defendants in this litigation. Indeed, many of them may be helpful in explaining the careful consideration which was given to various matters at the time. However, that is not the point." So, by that, are you saying if PII applies, then it applies as much to a helpful document as it does to an unhelpful document?
Yes, it applies to everything. I mean, it's important. So you can't cherry pick, clearly. But it's also important to note, for those who haven't read the document in the way that I had, if there were any red flag documents in there, because if there's a red flag document which is clearly favourable to the plaintiffs, then that may affect the way in which it is described in the certificate or in the way in which we present it to the court. And this was signalling that there was nothing there that, in my view, having read them, was, if you like, a document of significant benefit to the plaintiffs, which they would be disadvantaged by not having. They might not be able to have it because of the immunity, but I was seeking to be as fair because, again, although the department cannot waive it, if the judge is aware and told there are important documents in there, but this is a privilege, he has to balance, as I put above, the competing public interest in favour of disclosure or otherwise.
If there had been such a document, then would you have made explicit reference to it, both in this advice and subsequently in the certificate, so that the judge was particularly aware of that document?
If there'd been something in it, I would have made clear that there were documents. Whether in this particular document, I would have identified them as opposed to making provision for them to be identifiable. I suspect that, I don't know where they would have gone into the certificate because we never got that far, but I would have expected that either by way of the certificate or by way of the evidence and submissions which we put forward when it went before the court, we would have made clear that we do accept there are documents which may be of some relevance to this case, as opposed to whatever we did do, which I'm afraid I can't remember.
Returning then to this advice, if we could just turn to electronic page 12. As I say, you go through category by category, discussing the merits of a case for PII. And if we turn to paragraph 11, this is a reference to the fourth category, which is the category for briefing notes and draft replies to letters. What you say in the advice is this, and I quote, "The fourth category is rather more difficult. Ordinary briefings which do not relate to policy formulation are, in my view, matters which ought to be disclosed where their relevance and prima facie likelihood of assisting the plaintiff's case are established. However, if individual documents disclose information about the policies currently under consideration, there is a good case for considering these documents as a subcategory of the first category, which is policy formulation documents. The same applies to drafts of letters, unless it is considered appropriate to protect all direct communications between ministers and their senior civil servants from disclosure. It follows that this is a category for which I consider that privilege should only be claimed after careful thought. I see no objection to disclosing these documents if that is considered appropriate." Again, is that an example of not applying a blanket approach and instead considering it on a document-by-document basis?
Yes.
To the best of your recollection, is that what the central defendants did? Did they take this advice and take that approach?
To the best of my recollection, what happened was that following this, we put the ones which I thought did attract privilege and therefore had to be withheld in one, and those which fell outside it into another, and therefore they didn't form part of the claim as documents. I certainly have no recollection of my advice not being followed, and I think I probably would have remembered if it had been.
Did you play any role in discussing with individual civil servants the way that they should approach their sift through the papers?
I really don't remember. I mean, I will almost certainly have had some discussions about the kind of exercise and search they were carrying on. But I do have a recollection, it's one of those sort of moments of sitting there with files of original documents in the sense of carbon copies or whatever they were, or even originals with manuscript on them. And I think that I was probably given an inclusive rather than selected groups, anything which might fall within the category provided to me, as opposed to somebody else making the decision. But I don't recollect, and I think that I do know that because there were relatively few surviving documents, partly because in those days we didn't have the computer, that we write everything down, end as emails, and partly because of normal losses over time. There weren't many documents, so we were always talking about where else we might find some, and where to go and search, and what, whose old cupboard to look in, and what storage unit to look in. So I think we will have discussed where to go to find the documents, but because they're within this policy area, they're likely to be contained within a fairly small number of people. The civil servants down the food chain won't be involved in this. It's those very close to ministers, cabinet office, or whatever will be more involved.
If we could go, please, to electronic page 14 of the document. This is still within the discussion section. In paragraph 15, about halfway down, there's a sentence starting "whereas here." We could just highlight that. what you write in the advice is this: where, as here, the plaintiffs raise adventurous and novel arguments about the duty of care of ministers and the justiciability of decisions relating to resource allocations, I consider that it is quite reasonable to invite the court to consider whether the plaintiffs have made out a case that this is a cause of action which stands any real prospect of success in light of the authorities. If the claim is hopeless in law, then the importance of the evidence to the issue and the public interest in doing justice to the plaintiffs should not be allowed to outweigh a legitimate public... Can we go over to the next page, please? Thank you. A legitimate public interest in the confidentiality of the material of which production is sought. In other words, although the matter is not elevated to the status of a preliminary issue, the plaintiff may reasonably be asked to set out its case on these adventurous issues for scrutiny by the court. It is only if the court concludes that a prima facie case has been made out in law that the court should go on to consider the competing public interests and other tests advocated in Air Canada, which was one of the authorities that you cite in the report. Should we understand that then to be a suggestion that the court needs to consider whether or not there is actually a claim in law here as part of its assessment of where the public interest lies in either disclosing or keeping confidential these documents?
Yes, it is downstream of the selection of materials for which a claim is to be made and the decision of, in this case, Permanent Secretary to sign the certificate. And it's when it comes to the court considering it, in balancing the public interest. I mean, clearly, if you have what is a plainly viable claim in law and on facts, then there is a significant public interest in wider disclosure. If, on the other hand, it is a claim which is speculative and weak, whether on the facts or on the law, then the public interest may be in favour of retaining it. And all I was saying here is that some of these arguments are difficult, and it's legitimate to say that if you want the documents, you should explain to the court why these claims have a significant prospect of success. From recollection, and you'll know better than me because you'll have read it more recently, I think it must have been Mr. Justice Rucci at first instance concluded that the statutory duty claim would not succeed. Whether it made any difference to his choice or not, I don't remember. And the Court of Appeal said no, although weak, it was sufficiently arguable that any document which might be relevant to it could be placed in the balance with slightly more public interest in favour of its disclosure.
We'll come to the Court of Appeal judgment, but that's an accurate summary of it. And the point being that this, although the point is taken in respect of public interest immunity, were the court to find that a particular legal argument had no chance of success, then that would obviously influence the attitude of the plaintiffs and indeed the defendants to the litigation as a whole.
Yes.
Final points from this document. Electronic page 15, please.
Yes, I just note when you're on 15 at the bottom of it. Are you coming to the conclusion?
Yes, I'm just briefly going to mention paragraph 16,
yes.
Just to cover the point off that we mentioned earlier. Since the documents span two administrations, it's more appropriate that the certificate should be signed by the Permanent Secretary rather than the Minister, and indeed that happened. And then if we go down to the conclusions, paragraph 18, subject to the approval of John Laws, I would advise that the following approach should be taken to the question of claiming public interest immunity. And then you go through the different categories.
And that was particularly important because public interest immunity is a very powerful instrument affecting the disclosure of documents in this type of litigation. And it was, in my view, absolutely essential that there should be a consistent line taken. I mean, something went wrong when we came to the matters of the Scott inquiry because I wasn't involved, but the reported extent of the claim for PII privilege seemed to me to be just simply wrong. And I was very anxious to make sure that we were making a claim which was entirely orthodox, entirely conventional, and which was consistent with what the very experienced Treasury devils through the generations, most of whom got to the House of Lords, had concluded was the correct advice to give, rather than me forming an independent view. So his endorsement of it was, in my view, very important.
In effect, you were asking the most senior barrister instructed by the government as to whether or not your approach was correct.
Yes.
And to the best of your knowledge, he considered that it was.
Yes, he certainly considered it was right. Whether he made some small adjustments, I cannot recollect.
I'd like to go briefly to an additional advice that you provided. This is slightly out of sequence because this is given after the Court of Appeal judgment, but I'm not going to for that reason. If we could go, please, to DHSC 0046936_082. We can see that this is headed re-HIV litigation, additional PII documents, advice. I won't take you to the page, but it's signed by you on the 1st of October 1990. If we just look at the first paragraph, it says, I have looked at the additional documents provided to me and agree that, except as set out below, the documents are correctly included within the claim for public interest immunity and fall within the categories set out in the folders in which each document is contained. That would indicate that you have looked at those individual documents
yes.
in order to see whether or not they fall for PII.
Yes, in each case, I always looked at the individual documents, as opposed to giving them a description, letting somebody else do the selection.
We'll see from a Court of Appeal judgment shortly that there were about 600 documents for which PII was originally claimed. So would you have looked at each one of those 600 documents?
I'm afraid so.
I won't go through the rest of that advice, but as is implied by the first paragraph, you've identified documents where a claim for PII should not be made,
Correct.
as well as those for which it has been made. Let's turn then to the Court of Appeal judgment. It was handed down on the 20th of September 1990. If we could have RLIT 40657, please. We can see that the Court of Appeal was constituted of Lord Justice Ralph Gibson, Lord Justice Bingham and Sir John McGaw. The head note, and just for those who are not used to legal authorities, this is a report summarising the key findings of the judgment, which is then published in a law report. I won't take you all of the way through it. If we can see that just at the first sentence of it, that there are 962 applicants at that time. That number varies. A description of the case is given, and just towards the bottom of that paragraph, we can see discovery was given by the Department of Health of a large number of documents, but public interest immunity was claimed for some 600 documents dating from 1972 to 1986, mainly on the ground that they related to matters of policy. That's where I got the figure of 600 documents from. The head note then goes on to describe that the Department of Health had raised the legal arguments that you had suggested in your advice, and it summarises the ruling of Mr. Justice Rougerie in this way. It says, the judge held, for the purposes of the discovery application, so this is about 3/4 of the way down, just before ABC. I don't know if we can expand that. A little further down, just there we go, thank you. The judge held, for the purposes of the discovery application, A, that the plaintiffs had no claim for breach of statutory duty, B, that they had no valid coterminous claim in negligence based upon the same facts as the alleged breach of statutory duty. C, that nevertheless, in certain respects, a valid cause of action arose in respect of alleged negligence generally, both on policy and performance bases, and that accordingly discovery could be ordered. So you had some success, it seems, in the arguments on statutory duty and common law duty based on exactly the same facts, but there was still a claim left over in respect of other parts of the pleaded case. Is that a fair summary?
Yes, an arguable case, and I can't remember what weight he gave it, but it was certainly not something which was so small a prospect as to make it reasonable on that ground alone to withhold production.
And of course, it's important to say that Mr. Justice Rougerie wasn't saying that that claim would succeed, merely that it could be argued.
Yes.
Both sides appealed to the Court of Appeal, and if we could turn, please, to electronic page 2, the section under held. So this is a summary of what the Court of Appeal held. These aren't the judge's words directly, but these are the report of them. If I just read through that. Held, if it was sufficiently clear on the material available for the court to decide that any cause of action put forward by the plaintiffs was bad in law, then the court should say so, even though the effect of such a decision upon the future conduct of these proceedings between all parties might be unclear. 2. On the other hand, if there were good reasons for not making any decision with reference to the validity of the causes of action, the court could abstain from any such decision if, without making it, the appeal could be properly and fairly decided. There were good reasons for not making any such decisions. Both with reference to breach of statutory duty and to negligence, the case raised questions of public importance which were to be regarded as novel. It is usually undesirable, unless the case is very clear, for such questions to be decided upon pleadings as contrasted with findings of fact. 3. It was not clear that Parliament intended to impose a duty under the 1977 Act, that's the NHS Act, which would be enforceable by individual civil actions. But, although there was much doubt as to the existence of any cause of action for breach of statutory duty, the plaintiff's claim should not be treated as fit to be struck out, and the judge's order would be varied accordingly. On the other hand, treating the plaintiff's allegations for the purposes of appeal by consent as being true and being capable of proof, the plaintiffs had a strongly arguable case in negligence in respect of the defendant's acts and omissions in the performance of their functions under the 1977 Act. If there were so, Article 13 of the European Convention on Human Rights would not require a separate cause of action for breach of statutory duty. If there were no remedy in law for negligence by the defendants upon proof of the facts alleged. 5. The defendant's contention that negligence in the formulation and execution of policy should be non-justiciable failed. The plaintiffs have made out an arguable case, whatever difficulty in terms of proof might exist. 6. The judge's order for inspection would be varied in certain respects, but the defendants would be ordered to disclose the documents for inspection by the judge, who would decide whether or not the plaintiffs would be deprived of the means of proper presentation of their case without disclosure to them of the documents. Looking at the way the decision went, and as you described earlier, the Court of Appeal disagreed with Mr. Justice Rougerie about the breach of statutory duty.
Yes.
And held that there was potentially, arguably, a case in that respect. How did the plaintiffs, how did the defendants, central defendants, view this judgment and the words that were the judges used to express their views of the strength or weaknesses of the plaintiff's case?
It's very hard to put myself back into the position. I didn't even remember this judgment until I read it. So it is reconstruction. I don't think it meant that there was no immediate knockout blow, which is I think, justified the fact we never attempted a strikeout as opposed to preliminary issues. We always expected courts to be sympathetic and therefore to allow a hearing to proceed where there was an arguable case because of the severity of the consequences to the plaintiffs and their families. The wording of the judgment, which you may or may not go through, certainly in my view, looking at it again now and trying to do my best as to what we thought at the time, was that it supported our conclusion that these claims were going to be very difficult in law to bring home for the plaintiffs. There was no suggestion that this was a case which the department should be settling because it was wrong, nor was there a suggestion, in fairness to the plaintiffs, that they should pack up and go home. But there was a warning that the case was going to be a difficult one. So that wasn't very different from our own assessment. And I don't think it had any real impact other than just really reminding us of the balance between the sympathy of the court to the plaintiff's position and their awareness of the trickiness of the legal case.
I'm not going to go through in detail what the court has said. As you will have gathered from my questions, the inquiry's primary interest is in how the government of the Department of Health conducted the litigation rather than the fine detail of the legal analysis. What I will mention for the record is that we can see from the terms of the judgment, which describes how the application was made at electronic page 7, that the Department of Health had followed your advice as to the different categories of documents and included word for word the way that you had described the documents that fell within them, save for the fact that, as I mentioned earlier, categories 5 and 6 concerning international relations and the unexpurgated, unredacted versions of the yellow card system were not part of this litigation.
Yes, and I noticed when I looked, you were passing through part of my advice, that it appeared there were only 2 documents at most in the foreign government category, so that may be why it fell out of consideration.
What I would like to take you to is electronic page 10. It's page 229 of the law report. The third paragraph down, beginning the Department of Health. Thank you. This is what this is Lord Justice Ralph Gibson, but the other judges agreed with him. This is what he said in that section. The Department of Health has raised the matter of public interest immunity so as to prevent the disclosure of the documents listed above. The Department does not do that in order to put difficulty in the way of the plaintiffs or to withhold from the court documents which might help the plaintiffs. The Department raises the matter because it is the duty of the Department in law to do so in support of a public interest in the proper functioning of a public service. That is the executive arm of the government. See per Lord Denning, the Air Canada case. It is not for the Department, but for the court to determine whether the documents should be produced. The plaintiffs acknowledge the validity of the claim to public interest immunity, but ask the court to order production notwithstanding the existence of a valid claim to immunity. It is essential that that aspect of these proceedings should be clearly understood. We go on to the next paragraph, please. The valid claim to immunity is to be overridden by the order of the court if the law requires that it should be overwritten. The task of the court is properly to balance the public interest in preserving the immunity on the one hand and the public interest in the fair trial of the proceedings on the other. We'll stop there before we go into the authorities. This then is the court approving of the fact that the Department of Health had made the application in the way that it had made it. Is that fair?
Yes.
And also the reference to the fact that the plaintiffs acknowledge the validity of the claim to public interest immunity would seem to indicate that they too agreed that it was right and proper, and indeed a duty, for such an application to be made.
Yes.
It was then for the court to do that balancing exercise between the public interest in retaining confidentiality and the public interest in doing justice by having the documents.
Exactly that.
Thank you. We can take that document down now.
And I just observed that one of the things that the Court of Appeal did was to actually give the judge the further task of actually reading the documents himself in order to decide which ones should be disclosed. So there was a very careful filter at each level.
In your witness statement, you were asked, you responded to two questions that were asked by the inquiry about your impression during the HIV litigation, and I stress this is just about the HIV litigation now, about destruction of documents and PII. I'm just going to read those to you and then ask a couple of follow-up questions.
Yes.
It's WITN 706-7001, page 21. We could go down to the second half of the page, please, after or including subparagraph D. Thank you. The question posed by the inquiry in its request for your written evidence was this: were you aware of any of the central defendants, just pausing there, that's Department of Health, Committee of Safety of Medicine and the Licensing Authority, intentionally destroying documents for the purpose of ensuring that they were not disclosed as part of the HIV or other litigation? Your answer was, I have no recollection of being told or suspecting that there had been deliberate document destruction for this or any other improper purpose. I do not have any reason to suppose that such destruction took place for this reason. I do know that we were disappointed by how comparatively little material there was and consistently asked for further searches. But in those pre-computerized days, many, if not most of the documents we were provided with came from hard copy files of original memos and papers or carbon copies rather than from a photocopy archive. If my memory is correct, files were regularly reviewed and what was considered to be outdated and no longer relevant was destroyed simply to make the task of archiving files manageable. I was, however, not involved in any of the details of any searches, and I'm not able to say whether there was any deliberate destruction, although I can say that I had no impression from any of the multiple officials with whom I met that they were being evasive and potentially inclined to destroy embarrassing documents. Any more detailed inquiry must be for others to answer. I pause there and say the reason that I stressed that this was about the HIV litigation is that after you had written this, you've been provided with some additional documents about the HCV litigation, and we will come on to those separately.
Yes.
But in terms of the HIV litigation, do you still stand by what is said in that paragraph?
Yes, I've thought about it more as I got ready for today. And you know, there weren't as many documents as I would have liked, because when you're trying to put together your picture of the case, you want to fill in the gaps. And when there are gaps because documents aren't there, you say, surely there must be some documents, go and find some. But I had no perception of anybody being evasive, none of those, well, we'll try and look, no slightly shifty glances between people, nothing to suggest that they weren't doing the best job that they could, or that they were aware of some event which had happened where there'd been a dumping of documents. So I have no reason to change that.
I'm going to turn then to the next question that the inquiry asked of you, which was this. Were you aware of any of the central defendants seeking to abuse the PII process by claiming PII without proper reason in order to avoid disclosure of documents that might harm their case or otherwise cause embarrassment? Your answer was this: no. I do not believe that there was any such attempt. Of course, one of the categories of documents for which PII was claimed was advice to ministers, which was often terse and relatively informal, and there may have been a sensitivity about its disclosure because each phrase had not been carefully honed for wider publication. It is also not unusual for litigants and administrators to be embarrassed by some of the documents they have authored over the years and to hope that it may not be necessary to disclose them. I do not recollect whether there were any such feelings expressed in this case. However, the categories were clearly defined in my advice, and so far as I was able to do so, the claim was narrowly confined to documents falling within the relevant class. I was not conscious of any attempt improperly to influence my judgment or that of Andrew Collins or John Laws. I would not, in any event, have been influenced by such attempts, and if I had been asked whether PII could be claimed for any document or documents which might, on its face, seem a little embarrassing, I would have made clear that it would only be subject to a claim where that was, in my view, objectively justified. Again, do you stand by that evidence?
Absolutely.
A final question then on this, and just so there is no doubt about it. Do you now, or did you then, have any concerns about the way in which the Department of Health, the Committee on the Safety of Medicines and the Licensing Authority were discharging their duties to the court and to the plaintiffs in respect of disclosure of documents and PII?
PII, absolutely none, because as we've already identified, I looked at all the documents which the claim was made, and I was satisfied that it was properly made. So far as disclosure is concerned, discovery in those days, as far as I recollect, and as far as I was able to do so, there was no evidence of any improper or inadequate approach. It's always, in all old cases, doing stuff like tobacco litigation back to the 1920s, you're trying to find records, and the quality of finding stuff from archives and whether you've gone to every warehouse is always difficult. But we did ask for a lot of work to be done, and I have no reason to doubt. I mean, all the people I was dealing with all appeared to be genuinely trying to find the information, to get the answers. And I think many of the officials were as frustrated as I was that we couldn't find it.
I'm going to move on then to the question of expert witnesses. You have said in your statement that you weren't involved in the selection of expert witnesses.
Not that I recollect. You may have a document which says I was, but I've got no recollection of doing so.
I haven't seen a document where you were so involved, but do you have any recollection of what role, if any, you did play in respect of experts in the litigation?
No. I mean, I think if Michael Spencer was part of the team by this stage, I would have expected him to have been very actively involved in that side of it, so far as the council team is concerned. It's possible I was given CVs. It's possible I was being told what was happening. I don't remember meeting anybody. But then I think I've seen reference somewhere to Professor Will having been involved at that early stage. I can't remember. That may have been, I mean, he was involved in helping me over human growth hormone and over variant CJD. But I have a blank on experts, I'm afraid, which suggests to me I probably didn't do very much.
With that in mind, I'm just going to ask you a couple of questions which have arisen largely from other evidence.
Yeah.
The first is this, that we know from other documents that the central defendants instructed Dr. Elizabeth Main, Elizabeth Main from Belfast, a hematologist from Belfast who ran the haemophilia centre there. And the health authorities instructed Professor Bloom from Cardiff as expert witnesses. Both were well-known haematologists and both were involved in developing the practices on which they subsequently opined in their expert reports. Do you recall any discussion at the time of the difficulties that this may pose in the litigation, of having people who were actively involved in the events being the experts who commented upon them?
No, I don't. I mean, I can say from my general experience of this kind of case and other kind of cases that whilst you try and find experts who haven't been involved in it, if you actually want to have the people with the knowledge, they've very often been the ones who were involved in the development of the practices, because they're the ones who know most about it. I can see there are arguments about whether there's a degree of self-protection or self-justification about it on both sides. I don't remember a discussion. I suspect that if we'd found people who were entirely separate, who could have given evidence, we probably would have selected them. But beyond that, I really can't help.
I'm going to take you to some evidence that was given to the inquiry by Dr. Raymond on the 11th of May 2022. If we could have, please, on the screen, INQY 1000204. We could have, we can see first page of that document, but this is the inquiry's transcript of that evidence. If we could have, please, electronic page 53. And then the bottom right-hand corner, so it's page 212 of the transcript, the sentence beginning, "It may be submitted," line 17. This is a question from Ms. Richards, QC, counsel to the inquiry. "It may be submitted that the department," that's the Department of Health, "in trying to secure experts for the haemophilia litigation, were engaged in a form of expert shopping, trying to find experts who supported the Department of Health's stance in the litigation. What, if any, response would you have to that submission if it were made?" And the answer given by Dr. Raymond is this: "Well, I think I explained yesterday that in essence the way we selected the expert witnesses were people I knew, or people I knew of, or people, you know," go over to the next page, please, "that I could easily access. And then some of them obviously were from abroad. But in essence, it was a case of, you know, you get an expert witness, and what you're really trying to get from that expert witness is what they can honestly say. Now, obviously, as we alluded to yesterday, if an expert witness comes up and they basically are critical of a department from beginning to end, then I suspect we would not use them as an expert witness when a court case came. And that, I think, presumably would have been the judgment of the QC, Justin Fenwick. But I think those were a relatively small minority. I think the majority of the expert witnesses were trying to give their best evidence as they could see it." Now, that's what Dr. Raymond said. Firstly, in response to that, and you may already have answered this, can you recall being consulted about whether or not a specific expert should be used?
No. I may have been. I don't have any particular recollection of it. I don't think the approach is quite as Dr. Raymond would have described. I mean, I see he refers to me as a QC, which, of course, in that litigation I wasn't,
Yes.
although I was in the two subsequent bits of litigation in which he was involved. I have no idea whether he means that they would have asked me and it would have been my judgment as to what to do, or whether he means that he thought that I would say don't use them. So I don't recollect it. No, I mean, I have no recollection of. Let's try. I don't think so. I mean, I know that I can't distinguish one case from another from this period, but if they have somebody, we've asked them, they're very anti the department, they don't think the department did a good job at all, shall we call them as witness? Well, they're probably not the expert witness you want because they're not independent, because they've already formed a view. But I don't think anything more than that would ever have happened.
Am I right in thinking that you can't, as a matter of memory, you can't say whether or not you advised on an individual expert witness, but you've got no recollection of doing so?
Yeah, exactly.
Can I just be clear? What Dr. Raymond is saying seems to fit into two categories. If you look at, as a matter of simply of language, if you look at the top of what's on the screen, round about paragraph 5, he's down to, when he describes you as a QC, the end of paragraph 11, he's describing a process. This is what would normally happen or what you'd normally expect. He's not actually saying this is what happened. Yes. But it's the next paragraph, which is the one which does, I think, translate that general understanding into what he recollects, although he's not pressed on it, happened in this case. I think those were a relatively small minority, which rather suggests that he had in mind that there were one or two, or maybe more, one or two who did take that general view. But you can't recollect any of that. That may not have crossed your desk.
I don't recollect any of it. I think if Michael Spencer was involved, I would have expected him to have been dealing with the expert side. I think that if we had an expert who we regarded as an independent expert who was giving adverse views, then that's something which would have got into some of our other communications and advices, because if you've got somebody who is a bona fide expert who says, actually, I think the department got it wrong, that's relevant to your assessment of the merits, because if he does, so will the claimant and so will the judge. So I'm not sure whether he's referring to people who had... I have to go back to the issue over MMR and triple vaccine, which, again, I was tangentially involved in, I can't remember how much, and where there was, I think it was Andrew Wakefield, who had a very specific view, which later became discredited. So if you have experts with a bee in their bonnet, then you might say that's not a suitable expert. But I have no recollection of it in this case, and I think if it was somebody who had given a genuinely independent adverse view, I would have known about it and it would have featured in our advice.
Yes, thank you.
If I could turn to a different document. This is DHSC 0044876. We can see that this is a minute from Dr. Raymond, dated the 18th of January 1990, and it is the note of a conference about HIV haemophilia litigation that took place on the 17th of January 1990, and you were present, and also says in your assistant, Ms. Helen, presumably Helen Rogers.
Yes.
I should say there are a significant number of these notes of conferences. We're not going to go through them all. You've referred to many of them in your witness statement. This is one that was not provided to you before you wrote that statement, which is why I'm going to it now. If we could turn, please, to page 5 of that document. The second complete paragraph, beginning Dr. Raymond. The note says this: Dr. Raymond to furnish a summary list of expert witnesses for the central defendants to Mr. R. Powell. Witnesses as to fact should also be considered. Mr. Fenwick liked expert witnesses to prepare their reports in the format of initial skeleton reports and later structural reports. These would almost certainly need amendment during the course of the trial. On the expert witnesses, is it correct that you did like that approach of having a skeleton report prepared for you, or prepared, and later what is described as a structural report?
It must have been if it was recorded. I don't recollect it. I mean, this is. I can't remember the date of the Icarian reefer and whether I would have had that to hand, which was, of course, Peter Creswell's seminal guidance on experts and how their report should be prepared. I think what I was probably saying then is that we want to know broadly what they're going to say first so that we can see if they're covering the correct areas. And then they write their reports. Sometimes you send off an expert. If you just say, please write a report on this, they get entrenched and it doesn't actually cover the correct subject matter.
Do you recall taking any different approach to experts in this litigation to that which you took in your normal practice, if I may put it that way, at that time?
No. It would have all been very much the same.
The reference there to witnesses as to fact should also be considered. Do you recall which witnesses or what consideration was given to the factual witnesses that the central defendants should call?
No, there must have been consideration given. I mean, that seems to put Dr. Raymond in the centre of finding not merely experts, but also factual witnesses. There was certainly a difficulty with lots of people having retired in finding people to give evidence of fact. I actually have a complete blank at this stage as to, I mean, I see we got to the stage of having factual witness statements and exchanging them, but I don't remember them.
We're still trying to find out which factual witness statements were prepared, but can I just ask a general question on that point? Would there have been any difficulty with seeking to obtain a witness statement from somebody who held a mid-ranking level role in the civil service in this litigation? Is there any reason why that wouldn't be done?
Just thinking, I mean, in all of these cases, I mean, I've just been assembling some witnesses for a case about an old audit many years ago of a company which was subsequently found to be fraudulent, and mid-ranking people who were involved at the time often have a reluctance to come forward if they've retired. What we would have done, I think, and again, that would have been Michael Spencer as much as myself, is to look at the areas we wanted to cover, find out who was in post, who was still serving in the civil service and who had retired, approach them and persuade them to give evidence unless they were unwilling to do so or unable to do so because of health. Might there have been people who just didn't want to get involved? There often are. I don't have any particular recollection of it. But there should be no reason why, particularly civil servants. I mean, rather different from employees who've moved on. My view of civil servants is that's what they are. They are servants of the public. And if they've been involved in something, they should be ready to give evidence about it when called upon. Human nature isn't always like that. But we would certainly, if we'd wanted evidence, we would certainly have asked for it. We'd have identified the people we thought should give it, and ask somebody to go out and try and find them and persuade them to come and give evidence.
Do you have any recollection of being frustrated or in otherwise encouraged not to seek such factual evidence during this process?
I'm sure nobody encouraged me not to. If they did, they wouldn't have got a very good reaction from me. There was a sense of frustration at the lack of documents. I suspect that was probably a frustration at the lack of people to tell me what actually happened. But whether the genesis of that frustration was the passage of years or some reluctance of people to come out and give evidence, I don't know. In my experience over 40 years, there have been lots of occasions when people have not wanted to give evidence. I don't have any particular recollection of it here, but we would have wanted to try and get the best evidence we could find, and certainly in the documents, possibly. The fact that I don't remember witnesses particularly means either I wasn't involved in it, or that there weren't very many. If there'd been good, strong witnesses indicating things, I probably would have remembered something of it. But that's the best answer I can give you, I'm afraid.
Just finally, then, on this area of questioning, during, and back to experts rather than factual witnesses, during the litigation, and looking back on it now, the HIV litigation, did you have any concerns about pressure being brought to bear on experts, or any other form of inappropriate behaviour towards experts by the central defendants in the litigation?
No, certainly nothing which came to my attention. My job, and as I saw it, was to make sure that we got the best in the sense of the most truthful and informed evidence from the experts, rather than anything else. I think that there will have had to be pressure in the form of encouragement of experts to give evidence. I note when you sent me at some stage the plaintiffs' own internal opinion as to merits, that they had difficulty in finding experts. People who are involved in the heart of a crisis, particularly one with consequences as tragic as this, are often unwilling to get involved. So there may have been pressure to people to give evidence, pressure on people as to the content of their expert evidence. I certainly don't recollect, and if I had, I would have probably said something about it pretty strong.
So I note the time, and I'm about to move on to a different topic. I wonder if it might be convenient to break.
Take a break now in that case, and come back at 2 o'clock. 2 o'clock.